Hello everyone, myself Dr. Seema Rani from Khalsa College of Law, Amritsar. Today going to discuss the concept of Introduction to Indian Evidence Act 1872. The Indian Evidence Act originally passed by Imperial Legislative Council in 1872 during the British Raj. It contains a set of rules and allied issues governing the admissibility of evidence in the Indian courts of law. The term evidence is derived from the Latin word that is evidere, which means to discover a fact, to ascertain a fact, to prove a fact. In simple sense, evidence means all and documentary evidence which may legally received in order to prove or disprove of some fact in a dispute, either it's a civil dispute or a criminal matter, because Indian Evidence Act 1872 is uniformly applicable to civil and criminal proceeding. The Indian Evidence Act is divided into 3 parts, 11 chapters and 167 sections. The first part of this act deals with the relevancy of fact, that is a section 5 to 55. Second part deals with the proof, that is a section 56 to 100. Third part of this act deals with the production and admissibility of evidence, that is a 101 to 167. Next we talk regarding the short title and commencement and extent of this code, because that is a preliminary part of this act, section 1 to 4. First section deals with the short title, commencement and extent of this code. This act may be called as an Indian Evidence Act. It applicable to whole of India. Earlier, before 2019, there is a provision, this act applicable to whole of India except J&K. But by amendment 2019, the word J&K omitted from this act. Now this act is applicable to whole of India. And it also applies to all judicial proceeding, including court-martial proceeding, except court-martial convened under Army Act, Naval Discipline Act and Air Force Act. This act also does not apply to arbitrator proceeding and affidavit. This act also not applies to domestic inquiries, departmental inquiries and commissioner inquiries. That is a well decided in Kuldeep Singh versus State of Punjab's case. Further, we talk regarding the section 2nd. Section 2nd was repealed by repealing Act 1938. Now we talk regarding the section 3, that is a interpretation clause, or for those words without which one cannot understand the true meaning of evidence. First is a court. Court here means all judges and magistrates except arbitrator, who is legally authorized to take evidence. Now here question, why arbitrator is not included in the definition of a court? Because arbitrator is not bound to follow the rule of evidence. He is bound to follow the rule of natural justice. Second word is a fact. Fact here means physical fact and psychological fact. Physical here means a relation of thing or a state of thing of capable which is perceived by any senses. Second is a mental condition of which person is a conscious, that is a psychological fact. For example, a man heard something, a man saw something, that is a fact. A man has a reputation, that is a fact. A jar kept on a table, that is a fact. Next we talk regarding the relevant. Relevant here means when one fact is said to be relevant to another fact, when it is connected with another fact in such a way according to provision of this act. For according to provision of this act means 5 to 55 of this act. Next we talk regarding the fact and issue. Fact and issue means and includes either itself or in connection with another fact, existence, non-existence, disability, liability, right in any suit or proceeding. And first, in civil cases, the fact and issue here means there are 2 reasons satisfied. First reason here is that there should be a dispute between a party. Second requirement is that the dispute matters concerning with the instance. Fact and issue means affects either itself or in connection with other fact. Show existence, non-existence, liability, disability, right asserted or denied in a suit or proceeding. Now, we can say that is a fact and issue. In civil cases, two things are required. First, there should be an existence of a dispute. Second requirement is that dispute should be regarding rights or liability. In criminal proceeding, allegation framed in charge sheet is a fact and issue. In civil cases, framing of a charge is a fact and issue. Next, we talk regarding the definition of a evidence. Evidence here means all evidence and documentary evidence. All evidence here means all statements which court require or permit made before it by a witnesses. That is called to be a all evidence. Second is a documentary evidence. Documentary evidence here means all document which is produced for the inspection of a court. It also include an electronic document. That's called as a documentary evidence. In this act, documentary words interpretation is not exhaustive nature. It did not include a material object like blood stains on a cloth, photograph, weapon, which is actually admitted in a practice. For example, in VV Giri case, tape recording conversations is held to be a documentary evidence. Another example here, Abdul Wasi state, in this case, dog tracking is held to be a scientific evidence. Now next we talk regarding the classification of evidence. Evidence may be a direct evidence, circumstantial evidence, primary evidence, secondary evidence, hearsay evidence. Direct evidence here means those facts which is proved without the interference of another fact. For example, a man had heard explosion. That is a fact, direct fact. Next is a circumstantial evidence. In all cases, direct evidence is not available. For example, certain facts have happened suddenly, like road accident, crime, tort. That facts do not leave behind much direct evidence. In that cases, party will have to reconstruct the fact and issue before a court with the help of surrounding circumstance. That's called as a circumstantial evidence. In circumstantial evidence, one thing is must require, that is a chain of circumstances without any gap. Then circumstantial evidence is admitted as a evidence. Next is a primary evidence. Primary evidence here means the original evidence itself produced for the inspection of a court. That is given under section 62 and 64. Next is a secondary evidence. Secondary evidence here means copies, certified copies or copies of a primary evidence. Otherwise, primary evidence is admissible as a evidence, but in there is a few instance which is given under section 65 of Indian Evidence Act, in which secondary evidence is admissible as a evidence. For example, when primary evidence is not easily movable, for example lithography. Second is for example public document. In that public document, certified copies are admissible as a evidence. For example, the original document is lost without the negligence of a party. In that case, secondary evidence is admissible as a evidence on the place of a primary evidence. Next is a hearsay evidence. Hearsay evidence is admissible as a evidence in few instances. For example, section 6 of Indian Evidence 32, where there is a evidence is already admitted in a formal proceeding. Next an example as a section 17 to 31, admission and confession. Only in these exceptional cases, hearsay evidence is admissible as a evidence. Now, what is the meaning of a hearsay evidence? In short, we can say the second-hand information. When the person has not seen in transaction himself and he has heard from a other person, that is we can say that is a hearsay transaction, hearsay evidence. The Indian Evidence Act, under Indian Evidence Act, under few exception, evidence is admissible as a hearsay evidence. Next, we talk regarding expert's opinion. Expert's opinion, there are certain matters in which court take an opinion from experts. Now, question is who is an expert? Expert, that person where the person have a special knowledge or experience in that field. In this here we refer a case Abdul Rahman versus State of Mysore. In that case, goldsmith was considered to be a expert. Even then that person has not a special skill, special knowledge, but he have a experience on that matter. He himself not has gained any particular education, any special education, but that person has a knowledge on that subject. Experience is considered to be as a evidence in that cases. Thank you.